Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with the temporary occupancy agreement for the seller after closing. So ideally, as an agent, you would prefer to have a vacant house at closing so that when the buyer signs the paperwork and the title gets transferred from the seller's name to the buyer's name, it is the buyer's. The seller has already moved out and the buyer can move in. You are conveying a vacant house and all walkthroughs have been done. Everything has been finalized. Seller hands over keys and everything is all done. Unfortunately, that is not always the situation. There are times when a seller will stay in the property after closing and the buyer and the seller negotiate for this to happen. Again, from a buyer's perspective, you want a vacant house when you close. From a seller's perspective, you don't necessarily want to move and go to the moving expenses and the issues if the closing is going to be delayed or fall through. So from a practical standpoint, totally get it on both sides. From a contractual standpoint, really should convey vacant property and buyer take possession at time of closing. However, if there is a situation where the seller is going to occupy the property after closing, the buyer is granting them possession of the property after closing for a few days, there absolutely, as an agent, there absolutely is a document, and for the buyer and the seller too, there is a document y'all need to sign when you are negotiating this possession date up front. As a matter of fact, the 2017 GAR contract put in there a note for you as an agent to remind you to have this conversation with your clients and to attach the form. So in the 2017 purchase and sale agreement, under the possession paragraph 4B, possession of property shall be transferred to buyer property, you have a choice. There's a checkbox to check either A, at closing, or B, actually they're numbered, 1 and 2, blank days after the date of closing at such and such a clock. And then in the 2017 printing of the GAR contract, they added attach F-140 temporary occupancy agreement. So let's cover what that is. In the GAR F-140 temporary occupancy agreement, it is called the temporary occupancy agreement for the seller after closing. Now, it does say on here that it is not to be used if occupancy is going to be for more than 60 days. So why do you think it is for more than 60 days? Well, if a buyer is getting an owner-occupied loan at closing, one of the documents they sign says that they agree to take possession of the property. Some say 30, but most, I believe, now say within 60 days. So if a buyer doesn't take possession of the property within 60 days, potentially they could be committing mortgage fraud. So that's why this agreement is not to be used for more than 60 days. Now, it does say that during the temporary, on the GAR form, it does say the seller is responsible for maintaining all utilities, paying the bills, not making any improvements, and releases the buyer and all the brokers and all the agents harmless from any injury, liability, lawsuit, so forth, of anything that happens in and around that property during their occupancy when they no longer own it. Also, it states on this form that the seller shall bear the risk of loss of responsibility of the seller's personal property. So you sellers, you need to think, you listing agents working with sellers, once a seller conveys title to that property, they no longer own that property. If they don't own that property, they no longer have hazard insurance on that property. So make sure if a seller is going to stay in a property after closing, they need to have a conversation with their insurance company about how to insure their contents, their personal possessions, their stuff, as well as any liability insurance if somebody were to come in the property and get hurt, let's say. It also says that the seller is responsible for repairing any damage, normal wear and tear accepted. Now, in the GAR form, there is no compensation fee. There's no per diem lease fee for the time the seller is staying in the property after closing, after which the buyer owns it. The only fill in the blank for a dollar amount for the parties to negotiate is if the seller you put a date in here that the seller is going to stay in the property till such and such a date. If the seller fails to vacate after that date, then there is a dollar amount per diem for being a holdover that the seller agrees to pay the buyer. Now, the buyer's going to have a lot of issues if the seller isn't out by that date. But basically at that point, the seller specifically will be deemed a tenant at sufferance and all sorts of legal remedies to get that seller out. But the only fee mentioned in this exhibit is just for a holdover tenant, holdover seller. Also, one of the things y'all need to negotiate through, or maybe, well, just take a look at and be aware of, is on this fee, it says that the seller shall not keep pets in the property. So if the seller already has pets, y'all make sure and negotiate that and attach a pet exhibit, so forth and so on. In the event either party is forced to litigate with the other one regarding this possession issue, then the quote-unquote loser shall pay the winner's attorney's fees and court costs. Now, that is the temporary occupancy agreement in the GAR form. There is also an agreement in the RE contract package forms called Occupancy Agreement for Seller After Closing Exhibit, and this is RE 255. Now, again, agents, y'all really need to include these exhibits with your contracts if the seller is going to stay in the property for any length of time after possession. And on the RE form exhibit, it does say that many loans require the borrower to occupy the property within 30 or 60 days. So the borrower, the buyer, needs to make sure and work that out with the lender what the occupancy time frame is. Now the difference, the main difference, all the other things in there, seller is not a tenant but shall be deemed a tenant at sufferance if the seller does not vacate. The reason this form says specifically the seller is not a tenant is because of the Georgia landlord-tenant laws kick in on an actual lease. This is not a lease, this is just an occupancy agreement. And it also talks about the condition of the property, utility bills, no pets, liability insurance, and insurance for any of the seller's contents. But the biggest difference between the GAR form and the RE form for occupancy for the seller after closing is on the RE form, it does have a paragraph for compensation. It calls it a usage fee. Seller shall pay buyer at closing the usage fee in the amount of either a lump sum or X amount of dollars per month, prorated X amount of dollars per day, and then it has a beginning date and an ending date. So in the RE form, it does allow for a usage fee for the seller to occupy the property after closing. In the RE form, the only fee mentioned is a holdover fee if the seller fails to vacate. So you guys definitely really need to use these forms, because if you don't have these forms and a seller occupies the property after closing and then fails to vacate for a variety of reasons, maybe let's say they have an offer on another property and that falls through, or something happens, you have some potential issues in terms of how is the buyer going to get that seller out of that house? What is the legal foundation under which the buyer who now owns the house may operate to get that seller out of the house without any documentation other than a potential contract dispute from the purchase and sale agreement? So definitely you want to use those forms. Take a look at the differences between the GAR form and the RE form, and definitely have that conversation with your buyer and your seller regarding a seller occupying the property after closing. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education. And go Falcons, win the Super Bowl this Sunday. Woohoo!